The Jeanette Braun drama, TikTok bullying, is officially over. Well, not all the way. It's almost over. If you don't know what we're talking about, we are talking about a case that came out last year. It's been on pause since June of 2024, and nothing has really been going on there. It is a case where an internet attorney, but she's a real attorney in real life, and a TikTok star, Lauren the Mortician. The attorney is Jeanette Braun, who everyone calls Jeanette, and then she gets mad at everybody. But anyways, the way it goes is that they are suing two TikTokers and two YouTubers for alleged defamation against them based on opinions, according to the court, based on opinions that they had about them on the internet. These were TikTok personalities and YouTube personalities making commentary. Jeanette Braun and Lauren the Mortician did not like the commentary, and we finally have a decision about whether the court is going to allow this case to go forward. So we're talking about defamation. We're talking about putting these people in a false light. All of these things they're accusing these TikTokers and YouTubers of doing against them. And the judge, after, what has it been? 8 long months, has finally given us a decision on whether this is going to go forward. As you know, we are live. So if you have any commentary that you would like to give throughout the live stream, make sure you're dropping it in the live chat box. And if you're watching on the replay, make sure you're commenting down below what you think about this case and whether you think that the court actually got it right or whether they got it wrong. Should this case proceed the way that the court decided today? And if you forgot all the juicy details that was in the original lawsuit filed by Lauren the Mortician and Jeanette Braun, don't worry. We are going to go over the background and the facts that the court found to be important in making their decision on whether this case is going to go forward. If you already know the answer of if this case is going forward, go ahead and drop it in the chat. Let me know what you think. Drop it on the comment section if you're watching on the replay. And y'all, don't forget to hit the like button so that other people know that we have this wonderful information going on over here on the BriHive or with the BriHive. So let's go ahead and have Bossy B bring us in to the background to remind us a little bit about what is going on in this case and what the judge thinks was important in determining what decision they made today. So, and I'm sorry, not made today, but made a couple of weeks ago. Some of y'all know I went on a cruise last week, so we are a little bit late getting to this topic, but that's okay. We're going to get into the nitty-gritty of everything. Let's remind everyone what's actually going on, and that would be helpful if I actually shared it with the stage and actually had my life together, Bri. Let's go ahead and hide this and make this bigger, and now I think everyone can see that. I think y'all can see that, right? So this is the memorandum opinion in order from the court where Jeanette Braun and Lauren the Mortician is suing the defendants, Rebekah Day. Caffeinated Kitty, we have her name blocked out because she still does not want her name publicly, although the court has said it can be public. We're still going to protect her privacy here. We got them suing Lily Marsten. I spelled that wrong in the description, so I need to correct that. And Jessica Vazquez. Jeanette Braun, along with Lauren the Mortician, are bringing 16 total counts against these defendants. So they are alleging defamatory and injurious statements made over social media and podcasts, or both. Defendant Marsten and Vasquez and Kitty have moved to strike the claims against them, and in the alternative to dismiss those claims pursuant to Rule 12b-6, failure to state a claim, as we all know. Kitty has further moved to dismiss Propson's claim against her pursuant to 12b-3, improper venue, and Day has moved to dismiss the claims against her under Rule 12b-6, failure to state a claim. And the court goes ahead and makes us a lovely little table of all the things that these people are suing over. So as you see, Lauren the Mortician only really has claims against Caffeinated Kitty. Oh gosh, why is this scrolling so much? Only against Caffeinated Kitty is where she has the claims against. And then we have Jeanette Braun is suing all 4 people. She has a problem with every single person. We got defamation per se. false light, trade libel, tortious interference with contracts, tortious interference with existing and potential business relationships, intentional infliction of emotional distress. Okay, let's see here. Let's again get into our reminder of what's going in. So we're going to talk about the background of all the claims against all the, what do you call it? All the claims against all the plaintiffs. So background, just remind you, we got Lauren the Mortician's claims against Kitty. Probson is a resident of the state of Wisconsin and a licensed mortician, and Probson is Lauren the Mortician, y'all. Probson operates at least one social media account under the handle Lauren the Mortician, where she posts about matters related to her profession. Kitty is likewise a social media personality and self-described life coach villain who operates under the handle Caffeinated Kitty. Kitty is a citizen of Georgia. On or around October 24, 2023, Kitty published a video on TikTok where she accused Probson of being a transphobic and TERF. Specifically, Kitty said, Lauren the Mortician is a TERF. I have receipts, I have deets, and you should just go ahead and take a seat. TERF is an acronym meaning trans exclusionary radical feminist that at least one dictionary defines as an advocate of radical feminism who does not believe that transgender people identities are legitimate and who is hostile to the inclusion of trans women in the feminist movement. Receipts and deets are slang words used to mean proof or evidence. Love how the court describes that for us. Kitty further explains that the receipts and or deets reference were evidence of Probson liking incredibly transphobic and hateful rhetoric and content. Kitty later explained that she made the post because people were confusing Probson, were confusing her for Probson. Plaintiffs allege that Probson's online following, the allegations of, Plaintiffs allege that because Probson's online following, the allegations of her transphobia spread quickly throughout the internet and became the source of multiple posts, comments, and blog articles. The allegations lowered her standing in the community, dissuaded people in the content creation community from associating with her, to caused her to lose followers, and caused her to lose a contract with the travel documentary channel, various sponsorships, and possible contracts for a podcast deal. Plaintiffs allege that Kitty was aware of the contract with the travel documentary channel as well as Probson's sponsorship, and that Kitty specifically commented on the documentary channel's social media post to accuse Probson of being transphobic. So do y'all remember, now that we've kind of gone in to a few of the details of what's going on here, do y'all remember this case? Were you ready for a decision on this case? Let me know your thoughts so far. So that was Lauren the Mortician's claims against Kitty. The only person that Lauren the Mortician had claims against was Kitty. Jeanette Braun has claims against everybody. She has smoke with everybody. We're going to go through the background of the claims that she has against everybody. So let's go ahead and jump into that. Where is my share screen thingy? Y'all, they have like a different setup on StreamYard, and I don't know what's going on. So I'm going to see if I could put myself in a different little corner. I don't like that one. Let's see. That makes me disappear. We don't want that. Nope, I don't want that. Nope, I don't want that. Okay, just stick to what you know, Bree. Stick to what you know. I couldn't download the document, so that's why it's all funky set up, but hopefully it's not a huge problem. So let's go ahead and jump back into it. Braun's claim, Janet claims against Kitty. Plaintiff asserts that in the defamatory TikTok video where Kitty accused Probson of being transphobic, Kitty used a copyrighted photo belonging to Probson and a screenshot of a copyrighted text that Probson authored. Probson hired plaintiff Braun, an attorney and resident of Illinois, to file a Digital Millennium Copyright Act, DMCA, short term for it, complaint with the social media platforms hosting the video. Meta, the owner of those social media platforms, removed Kitty's post and temporarily locked her account because of the DMCA complaint. Plaintiffs allege that Kitty then began acting irrational and erratic, and out of their concern for her, called a non-emergency hotline to perform a wellness check on Kitty at her home. And they called multiple times. Let's not forget that they called multiple times saying that they were concerned about Kitty, and they don't even know this lady. So that's what the police say. So you don't know her, you just know her on the internet? You guys are being weird. Okay. Kitty then posted at least 2 videos on different social media platforms in which she accused Braun of filing false copyright claims and bad faith copyright infringement strikes. Kitty also began a GoFundMe page related to the DMCA complaint. On that page, Kitty published a letter that she had sent to Braun, which contained the subject line "false copyright claim," and Kitty stated, "I do understand how you have reached out with cease and desist to smaller content creators speaking negatively about Lauren the Mortician scandals. And while I understand your desire to protect a creator you enjoy, if you were not legally obtained as counsel for her, and I speak on this via my platform, your actions are going to cause her significantly more strife. Braun has more claims." And so those were her claims against Kitty. Her claims go to Rebekah Day as follows. Soon a new influencer entered the fray. Can y'all tell by the wording that the court is using that they find this to be quite a joke? They say soon a new influencers entered the fray. This is a mess, is what the court is basically trying to say. Plaintiffs allege that defendant Day is a self-stylized, unbiased content creator and independent investigative reporter who has no journalistic training. Day allegedly creates content and monetizes video that disparage social media creators and celebrities, and she has allegedly been accused of posting false and untrue statements about public figures. Day is a resident of Missouri. Day posted a deep dive video about the dispute and posted that she had possession or proof of another very large and well-liked content creator that is utilizing the same attorney that Lauren the Mortician has used, Braun, to harass a small creator on this app and misuse the copyright strike system to have her account taken down. In a separate video the next month, Day discussed another client of Braun's named Demps and accused Braun of filing false copyright strikes on Demps' behalf. Day is alleged to have learned about Braun's representation of Demps by communicating with a stalker, an anti-fan of Demps. Day published another video within the same month wherein she said, "I just wanted to make it very clear that my position is to ensure that there is not a rogue attorney on this app." Day has since deleted that video. Plaintiffs allege that Day has contacted Braun's client to intimidate them and interfere with their contracts with Braun. On December 11, 2023, Day created yet another post on TikTok in which she said that the Illinois Attorney Registration and Disciplinary Commission told her they received multiple credible complaints about Jeanette Braun, and they have assigned multiple attorneys to investigate this matter. Plaintiff alleged that prior to Day posting the December 11 video, Braun had in fact received no misconduct violations. Since Day posted the video, multiple individuals have filed requests to investigate Braun with the ARDC. Braun further alleges that the ARDC keeps all complaints and investigations confidential, and that to the extent anyone had complained about her or her practice, Day could not possibly have known that. So those are all the allegations that she has against Rebekah Day. Then we're going to jump over to, we're still talking about Jeanette Braun, mind you. And when you hear about this lawsuit, you hear people say, Lauren the Mortician are suing these TikTokers. Or Lauren the Mortician is suing these TikTokers. It's really Jeanette Braun. Janet is the one suing all of these TikTokers. Probson, Lauren the Mortician, is only suing one TikToker, and that's Caffeinated Kitty. Okay, so let's jump into the allegations against Jessica Vazquez and Lily Marsten. At or around the same time, defendants Vazquez and I hope I'm saying that right. I'm saying Vazquez. Okay, and Marsten, hosts and owners of a weekly podcast, began covering the controversy. Vasquez and Marsten played Day's video regarding Braun's representation of Demps on their podcast. In one video, Vasquez said that Braun used scare tactics to represent her clients, issued false copyright strikes, and was unethical and unhinged. Vasquez further states that she learned this from a couple of DMs and even an email from someone as well that is not a creator. Separately, in a tweet, Marsten said, "I gotta say, one of our biggest questions is I gotta say, one of our biggest questions in all of this is, do we think Demps knows that her embarrassing excuse of a lawyer is using her name while actively committing perjury? Someone might want to tell her. Marsten has since deleted the tweet. Vazquez is a citizen of Georgia and Marsten is a citizen of California. Then the court is going to go on and explain why they are making the decision that they're making regarding whether this is going to go forward. So just a brief recap of what has happened to get us to this point. So we have Jeanette Braun and Lauren the Mortician suing these 4 creators for the background information that we just went over. Caffeinated Kitty for saying that Jeanette Braun was a TERF and a transphobic. And then we have Braun is suing Caffeinated Kitty for saying that she files false copyright strikes and other things. And then we have Rebekah Day being sued by Jeanette Braun for saying that she may be a rogue attorney and that she uses this unethical behavior in other circumstances with other clients. And then we have Jeanette Braun suing Jessica Vasquez and Marsten for saying that Jeanette Braun deploys these kind of things against other people, and that her other client, Demps, whether she knows that Jeanette Braun is committing perjury on her behalf in filing these claims. So they filed a complaint alleging these things against them, defamation, putting them in a false light, interfering with their contracts, all of the things that they're suing for, right? And so the others, I don't remember if they respond or not at this point, but either way it goes, Lauren the Mortician and Jeanette Braun end up having to file an amended complaint. I think the defendants did respond to the first complaint and then also the second complaint. And then the defendants also filed motions to dismiss. And then Jeanette Braun and Lauren the Mortician filed oppositions to those motions to dismiss. And then we wait 8 months or so for the court to then let us know whether they're going to allow this case to actually be dismissed or if it's something that should continue to go forward. So here we go. Let me actually pull up something else that we have. Let's try this one. So I hope everyone is all recapped on that. It's a lot, but I'm hoping that it makes sense. So let me get back to where we were on the document, and then we'll jump into the anti-slap motions and the motions to strike. So let's see here. Here we go. So anti-slap motions and the motion to strike. Under Georgia and California law, an anti-slap motion to strike revolves 2 steps. First, the moving party must make a threshold showing that the challenge claim is one arising from a protected view, a protected activity. A protected activity under both anti-slap statutes is one which could reasonably be construed as an act in furtherance of the person or entity right of petition or free speech under the Constitution of the United States or the Constitution of the respective state constitution in connection with the issue of the public interest. And in order to prevail, what these defendants are saying is that they were speaking on something that was of public interest. The court basically goes on to say that the plaintiffs have the burden of once the moving party has made a threshold showing that the burden then shifts to the non-moving party to establish a probability that the plaintiff will prevail on her own claims. The court basically finds that them moving for anti-slap is essentially the same as them asking for a 12B6 motion to dismiss for failure to state a claim. So Vazquez, Marsten, and Caffeinated Kitty actually lose on this motion because the court is going to decide it under the theory under a motion to dismiss for failure to state a claim. So let's go ahead and jump into the next thing that the court actually rules on, which is the motion to dismiss for failure to state a claim and whether they agree with the defendants that this case should not go forward. So let's jump into that. We got to survive a motion to dismiss under 12B6, the complaint must provide enough factual information to state a claim to relief state a claim to relief that is plausible on the face and raise a right to relief above the speculative level. A court decided in Rule 12b6 motion construes the complaint in the light most favorable to the plaintiff, accepts all well-pleaded facts as true, and draws all reasonable inferences in the plaintiff's favor. However, the court need not accept as true statements of law or unsupported conclusory factual allegations. Dismissal for failure to state a claim is proper when the allegations in the complaint, however true, cannot raise a claim for entitlement, a claim of entitlement to relief. Deciding the plausibility of the claim is a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. So let's go ahead and start with count one, Probson's defamation claims against Kitty. We are under Wisconsin law. A claim of defamation must assert or imply a fact that is capable of being proven false, or it must assert an opinion that directly implies the assertion of an undisclosed defamatory fact. Kitty's allegedly defamatory statement by Probson do neither. So what does that mean? Although it's written weird, that Kitty's statement does neither. The court is basically agreeing with Kitty, and that what Kitty said is not defamatory. She's not stating this as a fact, none of the things, right? So let's see what the court's reasoning is. Here, we got Kitty allegedly stated that Probson is a TERF or a trans exclusionary radical feminist and that she is a transphobic. Probson alleges that being called transphobic is akin to being called a bigot or a racist. The problem for Probson is that the court universally recognized that allegations of racism or bigotry are not actionable in a defamation claim because they express subjective opinions that cannot be proven true or false. And we've talked about this on earlier live streams on this case. It's an opinion. They throw it around. It's basically thrown around indiscriminatorily. That's what the courts say. You can't really prove if someone's racist, is where the court's going with this. So her being called a transphobic and a TERF is opinion, as the court is saying. But remember, an opinion can be actionable if it's basically put forward on undisclosed facts and wanting people to find it to be true, similar to what we covered in the Megan Thee Stallion lawsuit. Is like, are you basing these assumptions on facts that you haven't told to anyone else that you are asserting as facts to be true? And then those are defamatory, right? So let's see what the court says. Kitty's claim that Probson is transphobic cannot on their own state a claim for defamation. But Probson urges that because Kitty claimed that she had deets and receipts of Probson's transphobia, her statement was one of mixed opinion rather than pure opinion and thus actionable. Indeed, Wisconsin law provides that this kind of statement may be actionable if it implies the assertion of an undisclosed defamatory facts as the basis of the opinion, similar to what we talked about in the Megan Thee Stallion lawsuit. But this argument also fails because the facts that Kitty implied the existence of were neither undisclosed nor defamatory. As to whether the facts were undisclosed, Probson alleges that Kitty called her transphobic because she liked posts by a conservative social media personality. Kitty then allegedly compiled a list of the posts that Probson liked, which contained transphobic and hateful rhetoric, and she allegedly showed that list of liked posts to her, in her public video. Remember, a part of the claim was that Kitty screenshotted things from Lauren the Mortician. She also screenshotted the like. She gave you what she was basing her opinion on. So the court is saying that was not undisclosed. She gave you why. She screenshotted the fact that Lauren the Mortician was following this guy. She screenshotted the fact that Lauren the Mortician's name was under the like of the post. This is not undisclosed, is what the court is saying. So Kitty then allegedly, or we already got that one. In other words, Kitty explicitly disclosed the facts that formed the basis of her opinion. As to whether the facts were defamatory, the facts that allegedly formed the basis of Kitty's opinions are not defamatory for the same reason that the underlying statement is not defamatory. They are more non-actionable opinions. Probson does not dispute that she liked the allegedly transphobic social media post. She only disputes whether the posts themselves were transphobic. And whether the posts themselves are transphobic, say it with me, guys, is opinion. So basically, Lauren the Mortician is like, yeah, I like those posts, but those are not transphobic posts. And Kitty is like, she likes those posts, and those are transphobic posts. There's no way that either one of them are going to be able to prove whether this is transphobic or not. Are they going to call this guy to the stand and say, did you mean for this to be transphobic? And then he is the fact finder. He's like, yes, that is a fact that this is my post and it was in fact transphobic. No, he will not be the tiebreaker of whether something he posted is going to be considered transphobic as it relates to one party or the other. So there we have that. Let me go back into it. I think I lost where I was. Okay. And whether those posts, were indeed transphobic is like Kitty's claim that Propson is transphobic, a matter of opinion that cannot form the basis of a defamation claim. Propson's claim for defamation fails because it is based on a non-actionable opinion. She cannot save that claim by buttressing it with other opinions that are also not actionable. Propson further argues that the claim of bigotry can be actionable if it is made with enough specificity to be verifiable. The defendant there she goes ahead and cite a case where they're accusing like immigrant workers. I don't want to really go through all of that. Where did I want to skip to? In this case, there are no relevant accusations of concrete or willful conduct that can be proven or disproven. There is only Kitty's belief that Propson is transphobic, buoyed by Propson's expressing her opinion by liking posts that Kitty's also believe to be transphobic. This cannot support a claim for defamation. As a result, count 1 of the amended complaint is dismissed with prejudice. Let's go on to count 2, which is for Braun's claims for defamation per se against Kitty. So where do we get from that? Lauren the Mortician loses. She has failed to state a claim that by Kitty calling Lauren the Mortician transphobic and a TERF, she has failed to state a claim because those statements by Kitty were opinion that are non-actionable and not supported by undisclosed support that are fact, right? So Lauren the Mortician loses. Lauren the Mortician no longer has a claim. All she can do at this point is appeal it and try to get the decision reversed. Do I think that she's gonna go further into this and waste more money and waste more time? Like I'm telling y'all, the court has not done nothing on this case since June of 2024. This decision came out, I think, like the very last day of February of 2025. So 8 months, can you count, Brie? No. 8 months, the court has not done anything on, or I guess they've been forming their opinions. Let me not say they haven't done anything, but it's taken us 8 months to get this decision by the court. Do you think that Lauren the Mortician is going to continue to try to, in my opinion, do the Streisand effect, calling more attention to these allegations against her? Like at this point, these things happened over a year ago. I think we're like a year and 2 months past when these allegations occurred. It might be more time than that, actually, because I think it was October of 2023. We're more than a year and almost a half past the allegations that Lauren the Mortician is making against Kitty. Are we going to draw more attention to this by filing an appeal when the trial court has already used the citations that the plaintiffs have made and didn't really side with you? I would suggest, and that I'm not giving advice, Lauren the Mortician, my opinion is that just let it go. It's already past it. This decision came out. Not a lot of people covered it. I think you move on with your life, right? I think you move on with your life, you cut your losses, and that's it, right? We don't need this to continue to go forward. Y'all let me know what y'all think in the chat and in the comment section. And let's go ahead and jump into Janet, okay? Janet is pretty much the rest of this lawsuit. There's going to be some things brought back to Lauren the Mortician. She's going to lose on all of them, okay? Let's just give a preview. She's going to lose on everything. Lauren the Mortician is going to lose on everything, okay? But let's get into Jeanette Braun, because Jeanette Braun actually does win on some things, right? She does win on some things. Not a lot, but she does win. So let's jump into what the court thinks about the claims that Jeanette Braun has made, and whether she should be able to go forward with the lawsuit. Count 2, Braun's defamation claims defamation per se claims against Kitty. In count 2, Braun alleges that Kitty defamed her by claiming that Braun filed a bad faith or false copyright claim against her, and 2, by insinuating that Braun was not in fact Probson's actual attorney, which I think was really stupid, and the court is going to call her out for that being really stupid. Under Illinois law, to state a claim for defamation, a plaintiff must plead facts showing the defendant made a false statement concerning the plaintiff, there was an unprivileged publication of that defamatory statement to a third party by defendant, and the publication of the defamatory statement damaged the plaintiff. Braun's defamation claim against Kitty fails for the same reason that Probson's defamation claim fails. The statement at issue is an opinion. With respect, Kitty's assertion that any copyright strikes were in bad faith or false, it is clear that the allegations of the complaint, it is clear from the allegations of the complaint that Kitty was only expressing her opinion that the copyright strikes was baseless. Kitty wrote that she would love further detail on your client and how the video had grounds for a copyright strike, as it clearly falls under fair use. Kitty stated she did not agree with the at-issue video violated any. She did not agree that the at-issue video violated any copyright law, and explained why. Because she believed the fair use defense is available. And even if she was not expressing an opinion, the terms bad faith and false in this context are too vague and unverifiable to be actionable in a defamation claim. And so you might wonder, when we cover the Megan Thee Stallion claim and her saying perjury, and this I think she lied on the stand, she perjured. We are going to get to that a little bit lower in this actual decision, because remember, Marsten is being accused of claiming that that Jeanette Braun commits perjury. So we're not going to go into it now, but we are going to get into it a little later. So let's go on Braun versus Kitty. Braun argues that Kitty's claims are in fact verifiable because Meta removed an at-issue post after Braun filed the DMCA complaint. This argument does not persuade Meta, as Meta is not an arbitrator of copyright disputes whose findings establish a verifiable fact what is or is not copyright infringement. Remember, we probably got an AI bot going through things and somebody said it's copyright infringement, and so they just flag it as copyright infringement. We don't even know if there's a lawyer actually reviewing these DMCA notices. We don't even know if there's a person reviewing the DMCA notices. My experience with DMCA notices is that it just automatically gets granted, and then it's up to you to do all of these appeals and everything else. So basically what the court is saying, although Meta, a third party entity, took it down under a copyright strike violation, I think what Meta tries to do is to cover their butt. And I personally think, in my opinion, that it's an AI system that decides whether something is a violation under the DMCA. I don't think there's an actual lawyer reviewing it. And one thing about being a lawyer is a lot of the things that we talk about, like, yes, we have laws, yes, we have to follow them, but it's also all about interpretation. So we're not going to get to a point where AI is taking over lawyers' jobs, because you need that human element to basically make creative arguments. Although the law says this is how we're interpreted, and while my client may have done this, they didn't do this, so it doesn't quite qualify for what they're saying. It basically is not a black and white answer, is my point. So the court said, just because Facebook said it was copyright infringement, well, TikTok didn't say it was copyright infringement. I believe it was on TikTok too. So just because Meta said it doesn't mean that it's law, right? Facebook, sorry, Mark Zuckerberg, is not law. It's not law. Kitty is allowed to believe that Braun and Meta were wrong in finding that she had committed copyright infringement and cannot be published in a defamation action for voicing that belief. Similarly, Kitty's insinuation that Braun may not have represented Probson cannot support a claim for defamation. Kitty is alleged to have said, I do understand how you have reached out with cease and desist to smaller content creators speaking negatively about Lauren the Mortician scandals. And while I understand your desire to protect the creator you enjoy, in bold, the court says, If you were not legally obtained as counsel for her, and I speak on this via my platform, your actions are going to cause her significantly more strife. This is not, as Braun frames it, an accusation that plaintiff Braun does not represent Propson and was just some rogue fan. By its plain language, this is Kitty speculating about what may happen if Braun did not represent Propson, and a subjective view and interpretation, a theory, conjecture, or surmise is not actionable. Yeah, she said, if you are crazy, you may go to jail. Essentially, if you don't represent her, you're going to cause some problems. That's not saying you don't represent her, you crazy rogue lady. That's not what she did. That's not what she said. She said, if you don't represent her, it could be bad for her. Then what Jeanette Braun could have said, no, she has hired me. I am her legal counsel. That's it. That's it. Now, if after that she went and kept telling people that you didn't represent her, that would be a problem. She was basically questioning whether you represent her or not. And if you're not representing her, back off. Back off, lady. So let's go on. The phrase, if you were not legally obtained as counsel, clearly sets up the subjective view or theory about what may result if Braun was not Propson's counsel. It cannot reasonably be read to mean Braun as a factual and, It cannot reasonably be read to mean Braun as a factual and verifiable matter did not represent Propson. I agree with the court wholeheartedly on that one. Count 2 is thus dismissed with prejudice. With prejudice, they can't bring it back. All you can do is appeal it. And then if the appeals court says no, you can appeal it again to the Supreme Court. And if the Supreme Court says no, then you are done. Nothing. Let it go. So, dismissed with prejudice. I forgot to say that Kitty's claim earlier was also dismissed with prejudice. So, Kitty is free on the defamation stuff, okay? She is free. You cannot sue her for it unless they appeal it and the appeal court says the trial court got it wrong and then they go forward, right? Or the appeal court or the Supreme Court says that she got it wrong. Is this worth the money to go forward on? My answer would be no. My answer would be no. This is not worth the money to go forward on as far as a defamation claim. Everyone forgot about this. It's gone. It's been 8 months since we've been active on this on the internet. Let it go. Let it go. Dismiss with prejudice. Leave us alone. The court does not want to be bothered with the pettiness. Too much pettiness going on. So let's jump into Jeanette Braun's next claim, because there's more she wants to say. So Braun's defamation per se claim against Day. Rebekah Day is now who we're on. In count 3, Braun alleges that Day defamed her by calling her unethical and a rogue attorney who files false copyright lawsuits. For the reasons discussed in count 2, this is insufficient to state a claim. A non-party to litigation or a legal matter is allowed to comment on the perceived motivations or quality of the lawyer's work and cannot be punished in a defamation action for voicing that belief. Count 3 does not mention that. Count 3 does not mention the ARDC statement wherein they allegedly said that ARDC told her they had multiple credible complaints about Jeanette Braun and the ARDC had assigned multiple attorneys to investigate the matter. And although Day addressed that statement in her motion to dismiss, Braun did not respond to it in her opposition. Any possible defamation claim related to the ARDC statement is waived as to count 3 and is dismissed without prejudice. So this is her first without prejudice, so she can bring this back. The reason why Jeanette did not win on this is because she didn't address it in her opposition. It was in the complaint. Day filed a motion to dismiss and she addressed the issue. And then Jeanette Braun basically ignored this issue in her opposition, essentially waiving it. It's no longer an issue because you didn't provide any argument as to why this should go forward. Because when you're doing a complaint, you just have to state a claim. You're not really going through the case law that supports your position and all of the things, right? So the court is basically like, you didn't address it, so we're not addressing it. Peace out. So Jeanette Braun can technically bring this cause of action back at a later time, as opposed to the causes of action against Kitty at this point. So Day wins on the opinion that she's a rogue attorney, not actionable opinion, but Jeanette Braun can refile or ask for leave to amend her complaint. Or no. she'll have to file a new complaint because her opposition is already over. So she'll have to file a new complaint on that one. So let's go ahead and now jump into Jeanette Braun's defamation claims against Vasquez and Marsten. Okay. And then we're going to jump into we're going to go through everything else kind of speedily because it's all based on this defamation stuff after this. And then we'll jump into y'all comments. So make sure y'all are letting me know your thoughts on the case. And if you're watching on the replay, don't worry, I will respond to your comments. I did a really good job at that for the last couple of weeks. So I'll respond to your comments if you're watching on the replay. So let's go ahead and jump into Jeanette Braun's claims against Vasquez and Marsten. We got count 4. Braun alleges that defendant Vasquez and Marsten defamed her by stating that she is unethical and saying that she has committed perjury. As to any assertion about Braun's ethics or the quality of her copyright claims, those are not actionable for the reasons discussed above. Remember, those are opinions. The perjury, remember, we talked about this in the Megan Thee Stallion complaint that we just covered, not last week, but the week before that. I know it's been a while, but remember, we just covered the perjury statement, right? The perjury comment is a different matter. The court repeats Marsten's tweet in its entirety below. I gotta say, one of our biggest questions in all of this is, do we think Demps knows that her embarrassing excuse of a lawyer is using her name while actively committing perjury? Someone might want to tell her. Publicly accusing a lawyer or anyone of committing a felony is no small thing. In Illinois, words imputing that a person has committed a crime are per se defamatory. Marsten argues that because the tweet does not identify any particular statement made by Braun that Marsten contends constitute perjury, the statement cannot be actionable. And so when we're talking about defamation per se, is that you are accusing someone of doing something so bad that the plaintiff does not have to prove that it hurt their reputation. If you're accusing someone of committing a crime, that's going to be defamation per se. If you're accusing someone of having like an incurable STD, that's going to hurt someone's reputation. Versus merely calling someone a liar, let's get into what the court thinks about that. So Marsten argues that, there we go. But Marsten does not cite any law to support that broad proposition. Marsten cites to Pearsall, where an Illinois court found that a general statement that someone is a liar not being put in context of specific facts is merely opinion. But Marsten's statement was not a general claim that Braun was a liar. It did not lack context. Marsten's tweet, which came after an 84-minute podcast episode wherein Vasquez and Marsten said that Braun was unethical, unhinged, and engaged in scare tactics in connection with her legal practice, specifically refers to Braun's representation of a former client and specifically accuses her of committing perjury, a crime during that representation. During the podcast, Vazquez also said that she and Marsten had received messages and that at least one email describing Braun's practices, giving rise to the inference that one of the messages contained evidence of Braun's claimed perjury. Now, remember, we talked about it in the allegations against Kitty. She said that she was a TERF and she had receipts and she had deeds, and she gave us a screenshot of the post that Lauren the Mortician was liking. She had disclosed the thing that she was basing her opinion on. In Marsten, she says she got emails of people telling her these things, but she did not post a proof of the email, right? She did not show that as this is what I'm basing my opinion on. So it's basically undisclosed facts that she's basing that opinion on. And again, calling someone a liar is different from saying that someone is committing perjury, which the court has and is deemed a crime. So unfortunately, she wasn't as careful. And a lot of times we're on these internet platforms and you're not really thinking about exactly what you say and how to word it to avoid legal liability, because most people that are watching these things are going to take it as opinion. But if you're hurting someone's feeling and they feel like they have a claim for defamation, then they may have a claim for defamation against you. But either way it goes, the perjury and then saying I have emails to basically support what I'm saying, you're basically wanting people to infer that it's a fact that she is or that she commits perjury. Unethical, different. That's your opinion. Can't really prove that to be true or false. But for perjury, that's a crime. She can go to jail for it. It can be proven to be true or false. Same outcome that just came out with Megan Thee Stallion. So Marsten also argues under Illinois law that, Marsten also argued that under Illinois law, when potentially defamatory statements are published in a setting in which the audience may anticipate efforts by the parties to persuade others to their position by use of epithets, fiery rhetoric, or hyperbole language, which generally might be considered as a statement of fact, may well assume the character of statement as opinion. Same thing, like I just explained, we're on this internet. We're not really thinking people are going to take what we're saying as fact. They know that it's an opinion, but there are little loopholes that is allowing Jeanette Braun to succeed on this claim. So that may well be true, but there is no rule that simply because one has posted something on Twitter, one has a license to accuse others of committing crimes. The fact that Marsten made her statement on Twitter does not mean her statement is not actionable. Marsten and Vazquez also argue that their statements are subject to a qualified privilege and therefore not actionable. In Illinois, a qualified privilege to a claim of defamation arises in 3 scenarios. 1, situations involving an interest of the publisher of the defamatory statement. 2, situations involving an interest of the recipient of the defamatory statement or some other third party. And 3, situations involving a recognized public interest. So basically they're saying it's their interest and also the public's interest in this information. Marsten and Vasquez claim their statement are privileged because they relate to their own and the viewer's interest in protecting their freedom of speech as social media content creators and not being subject to intimidating litigation tactics by Braun on behalf of her clients, as well as the public interest in protective speech on social media. It is far from clear, based only on the pleadings, that this was Marsten's intent when she stated that Braun was actively committing perjury. In any event, this remains an affirmative defense, but defendants have not established that Marsten's tweet was privileged for purposes of 12b-6. Count 4 survives the dismissal as to Marsten regarding her tweet accusing Braun of committing perjury. Count 4 is dismissed with prejudice as to Vazquez. So Vazquez is free. Jeanette Braun can appeal. If the appeal court agrees with Jeanette Braun, then she can basically proceed with the case. My opinion, again, is that it's not going to go forward. Now, what will be interesting if now that the hype, right, is off of the case, and there's only that one statement that Marsten made that is actionable and going through the court process and litigating and as much as it will cost, is this something that is likely to settle? I say yes, it will probably settle. Jeanette Braun will probably ask for a public apology. They might walk away with paying some of the attorney's fees. I think that would be fair. But litigating this statement, litigating this statement doesn't make much sense to me. Marsten sounds like she has an affirmative defense in it. And so you can't dismiss it on a failure to state a claim, because in order to have a defense, you have to state a claim. So the court is basically saying Jeanette has stated a claim on that particular statement, saying that she's committed perjury, because it's per se defamatory to say that she committed a crime of perjury, right? And filing these DMCA notices, which would be technically legal. The other thing that we haven't covered on this channel, and Runkle of the Bailey did go ahead and cover the copyright court. I don't know if it was a copyright court or whatever, that Jessica Vazquez and Lily Martin, they went through with Jeanette Braun. Jeanette Braun tried to get a reconsideration, and the copyright office, I don't know who they filed it with, honestly. They agreed with Vazquez and Martin, and that the copyright strike that she filed was not legitimate. She was not, I can't think of a word right now. She was not justified in filing that copyright strike. And so basically they won on appeal, or not on appeal, they won their challenge to the copyright strike. So most likely, if this does go forward, the affirmative defense that Marsten has will likely prevail, right? She will likely prevail on it. So like I said, maybe it might come out that Marsten give a public apology. That might be what it is, and that she wouldn't owe her attorney's fees, because like I said, Marsten will probably prevail on her affirmative defense, if that makes sense. I hope that makes sense. I feel like I was just rambling. Jeanette has stated a claim. Marsten will likely win on the affirmative defense. Let's just call it quits. Let's do a public apology and move on. Jeanette Braun. That would be my opinion on what should happen as an attorney in this world. So let's go ahead and jump into the next thing. So we're going to go into the false light and all of that stuff. And it's going to be kind of a sweep, right? Because everything, the false light, against the Braun's false light claims against Dave, Vazquez, and Kitty, Dave, Vazquez, and Marsten, all four of them, the court is saying they has to be dismissed because it's based on the defamatory statements. However, Braun's defamation claim against Marsten has survived dismissal, and Marsten made no other argument as to why the false light claim should be dismissed. Accordingly, defendant's motion to dismiss count 8 is denied as to Marsten, but count 8 is dismissed with prejudice as to Vasquez. So since Jeanette has stated a claim for the defamation with Marsten, hers is the only false light one that still exists, but all the other defendants, the false light claims have dropped as to Braun and Propson. And then Propson and Braun's trade libel claims against Kitty, Dave, Vazquez, and Marsten. For similar reasons, Braun's false light claims only count 12 survives, and only as it relates to Marsten under Illinois law. Commercial disparagement claims like trade libel must be based on false statements of fact and cannot be based on expressions of opinion. Neither party cites to any Wisconsin law that would be relevant to Propson's trade libel claim, but Propson argues that she is required to allege an injurious falsehood. As discussed above, Propson has failed to do so. Counts 9 and 10 are dismissed with prejudice. Count 11 is dismissed without prejudice. Count 12 as to Marsten and survives as to Marsten and dismissed as to Vasquez. So basically, Jeanette Braun can bring her claim for this the trade libel against Rebekah Day because she has the dismissal without prejudice, meaning that she can bring back those claims regarding the attorney commission in Illinois that said, well, where they said that the attorneys are investigating Braun for doing bad things. Jeanette can bring that claim again. So essentially the trade libel claim, she can also bring that again if she files a new complaint alleging the right facts with that one, and responding appropriately to the to Rebekah Day's response to her. Sorry, my brain is not working. To her motion to dismiss when she files it again. Okay, so count 8, Propson claims for tortious interference with contract against Kitty. So this is just the one of Lauren the Mortician against Kitty. To state a claim for tortious interference with contract under Wisconsin law, a plaintiff must demonstrate that a plaintiff must have had a contract or a prospective contract relationship with a third party. The defendant must have interfered with that relationship. The interference by the defendant must have been intentional. There must be a causal connection between the interference and damages, and the defendant must not have been justified or privileged in the interference. Propson cannot satisfy the 5th element because she has not pled any facts showing that Kitty's alleged interference in any contract was unjustified. The law requires a defendant conduct may only be found justified if the means employed by the defendant are lawful. There's basically no allegations that Kitty did anything unlawful to interfere with it. Basically, Kitty commented on Kitty allegedly commented on the documentary, who she was going to work with on the documentary on their post. So it's not illegal to comment on someone's social media post. So essentially, Lauren the Mortician loses at that. Braun's claim for tortious interference with existing and potential business partners against all defendants. Essentially, Jeanette would have needed to name specific contracts that these people interfered with. So it's dismissed without prejudice. As to Rebekah Day, I think that's to Rebekah Day. I don't remember. We'll keep going. Okay, Propson claims for intentional infliction of emotional distress against Kitty, and Braun's claim for intentional emotional distress against all defendants. As an initial matter, courts generally dismiss intentional infliction of emotional distress claims when they are premised on non-actionable defamation. So basically, everyone else's get dismissed except for Marsten. So let's see. And then the motion to dismiss that Kitty filed against what's her name? Lauren the Mortician is basically, it's not upheld because no one objected to the personal jurisdiction of the court. And since all the defendants live in a different place, Illinois was the proper court found by the court. So essentially, all the claims against Caffeinated Kitty, dismissed with prejudice, can't bring them back. One of the claims against Rebekah Day, dismissed with prejudice, cannot bring it back. But the allegations regarding her contacting the attorney board, I'm going to call it the Attorney Bar Association, I think it's like AR, whatever it is called in Illinois, saying that Jeanette Braun had disciplinary actions filed against her. That one's dismissed without prejudice, so that one can be brought back. And so the trade libel can be brought back on that one as well. And then as to Vazquez, all things dismissed against her. But as to Lily Marsten, it is the defamation claim regarding the perjury allegation alone, not the unethical and unhinged and all of the things, all of those ones go away. But on saying that she was committing perjury, even though it was a question, literally the same thing that we found in the Megan Thee Stallion case that we covered a week ago. Literally the same thing. Since she said it was perjury, you're alleging a crime. That one is being upheld, but it does sound like she has a pretty good chance at arguing the affirmative defense and prevailing on that. So I anticipate that this case will be dropped. I think it should be dropped. It absolutely needs to be dropped. I don't think that anyone should waste any more money on this. And maybe, just maybe, if all Jeanette Braun wants is an apology, I would suggest that Marsten just do it and move on with their lives. Like I said, Jeanette will probably prevail on showing defamation per se. Lily Marsten will probably prevail on her defense, affirmative defense, that it was a false copyright strike. It was. She got shot down. Okay? So she needs to go away. She needs to go away. Y'all let me know what y'all think. I'm going to go ahead and jump into the comments. Shout out to Kimmy for marking all the ones where we are talking about the case. If you have comments, you have questions, you have concerns, make sure you're dropping it in the chat box. And if you're on the replay, make sure you are dropping it down below in the comments so that we can go over it. Let's go ahead and have Bossy B bring us in. Like I said, this thing needs to go away. It absolutely needs to go away. But let's see what the BriHive has to say about it. And hello to everyone that is in the live stream that I haven't had the chance to say hello to. We're going to look at the chats that are talking about the case. But just want to acknowledge everyone for being here. And if you haven't already, please do hit the like button. We are so close to 30 likes. We're at 28 likes. So if you have not hit the like button, please do. It does help us out on the channel, and we will play the like goal if we do hit 2 more likes. Okay, that's a really small goal. Okay, y'all. I think we can get 2 more likes. We got Phoenix Wallace saying, yay, Janet drama. Yes, it is Janet drama. Here we are. And I think she got what she deserved, right? I think she got what she deserves. Only one claim essentially is sticking, okay? Phoenix Wallace says the whole case is one sentence. Whoa. They said mean things about us on the internet. Whoa, yes. Oh, their opinions are not favorable to us. Court, please punish them and make them give us money. Like, dude, this has been gone for like 8 months. Let's just let it go and like, let's not bring more attention to this. Like, it's over. It's absolutely over. There's no reason for us to continue to talk about this. Mary Jane, really not Sarah. Hello, saying, I remember someone got swatted. What do you mean got swatted? What does that mean? Oh, are you talking about how they called the police on Kitty? On Kitty? I don't know if they ever actually, oh no, they did actually go to her house, but I don't remember everything. It's been so long, right? Phoenix Wallace says to Mary Jane, really not Sarah. Yeah, Janet and Lauren called the welfare check on Kitty, then sued Kitty. Yes, I do think someone did end up going to the house. Mary Jane says, Phoenix Walker, yes. It's awful what they did. I agree. Kimberly Rudd says this is ridiculous. It is absolutely ridiculous. Anytime you got internet lawyers suing content creators. I mean, I guess not, because we just covered a case where Legal Eagle is suing PayPal. So at least it's not other content creators. Like, it's opinion. Like, don't get on here and say that don't get on here and act like this person is just spitting facts about you, right? It's their opinion. Everything else they said was opinion. Perjury, yes, it's a little bit extreme to be saying, but dude, like, are we really wasting our money on this? Zello Spoo says, if this is a defamation suit, the copyright appeal decision is also deliciously LOL-tastic for Jeanette. I have not had an opportunity to go over that. I know Runkle of the Bailey has gone over it. We got Kimmy Locker, member, moderator, consultant, paralegal of the channel. Welcome in. Saying to Zello Spoo, yep, this is the court's order in the defamation lawsuit, and the copyright claim board also smacked down Janet's nonsense, specifically her copyright claim against Marsten and Vazquez. So yeah, like I said, I think that Marsten will be able to prevail on her affirmative defense if this were to continue to go on. And that's why I think they should just stop. I think they should just voluntarily dismiss it and move on with their lives, which y'all, remember, this is off topic. Okay? Off topic. But remember how in the Jay-Z lawsuit where the 13-year-old girl was suing Diddy and Jay-Z, right? And they voluntarily dismissed the lawsuit. And we talked about it in the chat and saying, well, what is Jay-Z going to have to do to be able to clear his name? What is he going to have to do to be able to clear his name? Well. Jay-Z is doing something. Although it's voluntarily dismissed, there's no public apologies. People are still thinking that Jay-Z is guilty until he can prove otherwise, right? Because when we're talking about hurting children, that's a big allegation. So until he can prove otherwise, he is still under, I don't even know what he's under, but people are not happy with him still. So Jay-Z, somebody revving that engine. Jay-Z is actually suing Busby along with Diddy. Diddy and Jay-Z are suing Busby in New York federal court. So we are probably going to cover that at some point. And he is also suing the 13-year-old, or the girl that was 13-year-old at the time of the allegations, because he is saying that she admitted that the story was false to one of his representatives. So there is some juice still going on in that case. I would love to see how that's going to happen, how that's going to turn out. So like in this case, I do think that it should be dismissed and voluntarily withdrawn, right? But I'm wondering if these defendants, and I guess these particular defendants are not going to sue them because the court already ruled in their favor. A lot of them are dismissed with prejudice. But Jay-Z is suing Busby. Again, mind you, he already sued Busby in LA court. He's suing Busby now in New York federal court, and he's suing the actual plaintiff in that case. I thought it was like some type of agreement, but I guess it was not. Normally, when you are voluntarily dismissing something with prejudice, because remember, it was voluntary dismissal with prejudice. Usually when you do something like that, there's some type of agreement, NDA, I won't do this, I won't do that. Looks like Busby didn't get none of that. He just withdrew with prejudice, so he can't even file this lawsuit again. But Jay-Z is suing him and his client. I just thought that was ridiculous. We'll probably cover it at some other point. Let's jump back into this case. Mary Jane says, who's Vasquez and Marsten? They are YouTubers that have a podcast. Kimmy Locker says to Mary Jane, Marsten and Vazquez co-host the Do We Know Them podcast. They discuss the Jeanette situation and beat her aforementioned copyright claim with the copyright claims board. Yes, exactly. Yep. Kimmy got it. Kimmy better explained it than me. Mary Jane says, buttress makes me think of butt bandages and butt mattresses. Yeah, it's a weird word. Phoenix Wallace says, 10,000%. Lauren and Jeanette are going to try to appeal because their fees are her tea. No. You're going to waste more money. The Court of Appeals usually give a lot of discretion to the trial court. So no, don't appeal it. It will not be a good idea. Zella Spoo says she totally seems like the kind of person to keep going because she thinks she's right. She got to let it go. She got one that stuck. one that stuck is bad. Okay. And this is how it says this case is wild. It indeed is. Kimmy Lockett says, I hope Janet learns from her motion for the CCB, the Copyright Claims Board, to reconsider and let this go. The way they went in on how wrong she was is embarrassing, but a finding that she committed perjury could be catastrophic. Yes, like the court said, it is a crime. It is a crime. I'm gonna have to read it. I didn't have time. Kimmy told me I started to watch it and I didn't have time to finish it. So I need to watch Uncle of the Baileys or get the documents myself so I can see what it says. But yeah, the perjury, Kimmy, yes, it is catastrophic, because then people are going to be looking at one, the court probably has an ethical duty to report her to her state bar. And then the court probably has an ethical duty to pass the case over to prosecutors to determine whether they are going to prosecute her for perjury. So yeah, I think she should let it go too. Phoenix Waller says, I mean, if you watch what happened with Bunny and CC, Janet might have been actually issuing copyright takedowns without her clients knowing. That was another allegation that was going on as well. Zealous Boo says, yeah, but most people wouldn't have bothered to try to sue about this in the first place with a lawyer. I hope most lawyers would not take on this case. That would obviously fail. Exactly. And I think when we talked about this before, and these are just my speculations, I can't remember if this is accurate. I believe that the attorney that they actually hired was, Jeanette Braun's friend, and was not a very experienced lawyer, if I remember correctly. So don't quote me on that. Destined to Be says, some people really have too much free time. Shaking my head. That is absolutely true. They have way too much free time. And Jeanette, we haven't been seeing her around TikTok. I haven't been seeing her around TikTok, so she might need a little bit of attention going on, right? Just Me MD says, we have gotten to a place where we think freedom of speech means I can say anything I want and I'm protected freedom. Kind of, but not really. I think some things, like I said, I think the court got it right in the sticking the perjury, but also like it's a commentary channel. Like, do we really think that we are spewing facts? That's why we only cover like actual lawsuit documents on this channel, so that people cannot say that I'm lying on them. We are reading litigation privilege documents, okay? Zello Spoo says, oh, hell no, I wouldn't take a deal from Janet for this. I would be stubborn one in that case. Run the bills up. Gabrielle George says, have you seen / read the Copyright Claims Board findings? It's scathing. I have not. I think it will be good. I am going to read it. Kimberly Russ says, Jeanette needs to just go away. She should. How is her TikTok channel doing, actually? Let's actually look into that. Let me not have my TikTok blazing when I go out there. What's her name? Jeanette. What? It's a Braun IP, right? Braun IP. Is she still on TikTok? I don't know if she's on TikTok. What was her TikTok channel? Braun attorney. I can't find her channel. Am I blocked? I don't think I'm that cool. I don't know. I don't remember what her TikTok channel was called, so I can't find her just by searching Braun IP. So y'all let me know if y'all know her TikTok channel. Just Me MD says, freedom of speech is not a wall of protection to say what you want. It is going to cost you something. I agree with that. The thing is, it's like, it's a commentary channel for me. I think they took it too far for suing. I think the court got it right on everything else. Or everything, actually. I think the court got it right. So hopefully they let this go. Gabrielle George says, Jeanette doesn't seem inclined to quit while she's ahead. Right, like filing a reconsideration improperly. Kimmy Locker says to Gabrielle George, or while she's behind. She literally only is winning on one thing, okay? Mary Jane, really not Sarah, said Jeanette might get through this if she ate crow and apologize and truly change. Is this going to happen? Questions that need answers. Kimmy Locker says to Mary Jane, the internet's so big that I bet she could get through this by dropping it. But if she doesn't and is found to have committed perjury, it could hurt her more than reputations. Exactly. Because like I said, the judge could have an ethical duty to report her. Other attorneys can have ethical duties to report her. And the judges can have ethical duties to refer her to the prosecutors, to the DA. Okay. A says, I can't believe Janet didn't get in trouble in terms of her standing as a lawyer. We don't know. She says she doesn't have any claims against her, but we don't know. We don't know. Rihanna Y says, late to the party, but just in time to like the video. Hi, all. Hello and welcome in. Thank you for hitting the like button. We got Zello Spoo saying she's either perjurious or incompetent. I don't know which is better. And that is opinion, right? We don't know until this goes forward, right? If it goes forward, copyright court has already agreed with Vasquez and Marsten. I don't know. But you can't say she's perjurious because that's the bad one, okay? Just Me MD says, does Jay-Z and Diddy really want to be under deposition if the lawsuit went forward? Won't they have to be deposed? Yes. Yes. Is it a good idea? No, absolutely not. Like the other lawsuit that Diddy filed. Is it a good idea? No. You can't then argue Fifth Amendment protections when you're on for a criminal trial if you're filing civil lawsuits. I don't think it's a good idea. He's Jay-Z suing, that's fine. The thing is that the evidence is gonna be so old. And if he really has statements from the plaintiff saying, you know, yeah, I lied and I was told to lie by my attorney, then it's an easy case. They don't really have to prove it didn't happen. They just have to prove she admitted to lying. Inconsistent statements, right? So it's not a good idea. It could expose some other things about them, but hey, they got the money. They're going to do it. The thing is about it is that they have the money. That plaintiff does not have the money. Remember, she had Busby suing personal injury, claiming personal injury, essentially. So it was probably on a contingency fee. So she didn't have to pay anything out of pocket. For her to defend herself against this, she's going to have to pay something out of pocket. So what's likely going to happen in this case? It's probably never going to get to depositions. It's never going to get to the discovery phase to where they need to be deposed. The plaintiff is most likely just going to admit that they lied, okay? And then where the Busby lawsuit comes into place is he is going to have to basically, with the plaintiff, they'll probably settle and she'll just give a public statement that she lied, right? That's most likely what's going to happen with the plaintiff. For Busby, he is not going to be able to really defend himself because he's not going to be able to testify to whether he encouraged his client to do certain things because it's going to be protected by the attorney-client privilege. And once the plaintiff says, yes, my attorney said that I lied to lie, that specific statement is no longer going to be protected by attorney-client privilege, and it's going to open him up to malpractice. So we're probably going to see some type of settlement to where Busby is not wanting to depose Jay-Z and try to get some type of settlement off the record and some type of public apology and say, hey, I found that the allegations were not accurate, and that is why we withdrew the case without prejudice, without him basically admitting to committing malpractice or to prevent Busby from violating the attorney-client privilege, if that makes sense. Gabrielle George says to me, Jeanette's attorney uses his university email as his contact info, so maybe a recent grad. I think that's a little worse. Oh my gosh. I figured he was like 1 or 2 years in, but not the university email. I can't even get in mine anymore. Angie says hi to me. I haven't caught I can't read. Hello, Angie. I haven't caught a stream in a long time. Love that you are covering this. Janet is so unhinged, and you can say that because it's opinion, right? According to the court. Well, we're happy to have you in the live stream. Angie says, rumor has it she used to work for the Illinois Bar Association. Janet, wow, that's interesting. I hope that's not true. Hope it's not true. Zello says both sides supposedly have statements from her. From the plaintiff in the Jay-Z case. I think that's what you're talking about. For Jay-Z case, I just wonder if she is the sort that is swayed by people around her about what she says. This is just weird. The thing about the Jay-Z case is, yes, she from her interview, it does seem like she has some mental instability, and it does sound like she has been through a lot, and she probably got approached by this attorney, and this is just my opinion, and by the way that Jay-Z is describing the case, approached by this attorney saying, I can win you some money. All you have to do is say this. I wouldn't be surprised if she did it. So we are going to definitely check out what is going in those lawsuits and what evidence Jay-Z is saying that he has to be claiming that, hey, this lady lied on me. I want something in writing or out publicly of her admitting that she lied and that Busby is also a liar. So that one, maybe we get Busby's license taken away. Well, I don't know what Jay-Z's goal is going to be in this. But as far as Jeanette Braun, this case, I think they need to drop it. I think Kimmy is absolutely right that if this continues to go on, it is going to be worse for Jeanette Braun than it could get better, especially with the copyright claims board going in favor of Lily Martin and Jessica Vazquez. Kimmy says, even without perjury finding, if the CCB, the Copyright Claims Board, and this court both determined the claims were bogus, I think the girlies and others like Jamie could reasonably sue her for unfair competition and business torts. Yeah, and a lot of things can come out of it, right? A lot of things. Gabrielle Jordan says, if it's true that she used to work for the Bar Association, as my grandparents would say, well, look how the mighty have fallen. That's a good one. I don't know if I ever heard that one. That's a good one. That is all I have for today, y'all. Thank you for joining me in talking about Jeanette Braun and the nonsense that continues to go on with this lawsuit. I anticipate that we are going to see a voluntary dismissal coming out here soon. Is going to be with prejudice as to Kitty, Rebekah Day, partially to Rebekah Day, and then to Jessica Vazquez. And then I think it's going to be without prejudice. I think they should just do it all with prejudice. Don't bring this back. Leave us alone. I think that should be the agreement. If that's the agreement with prejudice, I won't bring it again. I think that Lily Martin should just apologize for saying it and say, I didn't realize that would be considered defamatory. I meant to say it as an opinion, but apparently that is not an opinion. I am not versed in the legal community. That's what I hope, and get it dismissed with prejudice and a stipulation. And I'm seeing a comment from Destin to be saying we hit our like goal. So where are we? Yes, we did. Oh, we are way over. What did I just do? We are way over. So let's go ahead and do our like display. If you are sensitive to the loud sounds, this is your time to turn down your volume. I'm going to play the like goal in 3, 2, 1. Shout out to the BriHive for hitting the like goal for the live stream. I definitely appreciate it. We will be back here tomorrow live doing Reddit reads. I actually pulled together a couple of Reddits that talked about going on the cruise, since I went on a cruise last week and I didn't have time to cover it while I was actually on the cruise. So we are going to do Reddit reads on cruises, and then on Thursday we will probably cover all the nonsense that's going on with Jay-Z suing Busby and his plaintiff to see what kind of allegations Jay-Z has against them. If y'all have any suggestions on cases that we should cover or cases that you're interested in, feel free to drop it in the comments. Let me know what you would like to hear or learn about next. And I will see y'all all on the next live stream. Bye.